The Hamilton case involves a question of mistake of fact. Now, we're going to be talking in the next few cases about the distinction between mistake of law and mistake of fact. Under a mistake of fact, you think factual circumstances are different than they are. Under mistake of law, you think the law is different than it is. There will be cases that wander between the border of these two, and when you start to think about that border, you'll begin to think that maybe the distinction between mistake of fact and mistake of law is completely non-existent. And at the border, there will be things that are confusing as to which side they fall on. We're going to start off with some fairly easy cases in this way. The first one is Commonwealth versus Hamilton, in which the defendant puts a gun to the head of the son of his live-in girlfriend, and of course, there's been some feuding and dispute in that family relationship for some time, or this wouldn't have happened. Puts a gun to the 18-year-old's head and pulls the trigger. The gun doesn't go off. He pulls the trigger again, and the gun does go off. He's, of course, charged with first-degree murder. The question then is whether he knew the gun was loaded. At least that's what his defense is. He claims he didn't know the gun was loaded. So if he made a mistake of fact, he may well have been reckless extremely reckless in putting a gun to a kid's head and pulling the trigger. But he wouldn't have had the intent to kill if he didn't actually think the gun was loaded, because he wouldn't have thought this action would have necessarily brought about that consequence. So we can't infer his intent from the pulling of the trigger if he doesn't think the gun is loaded. So does he get to have the jury consider this mistake of fact? Consider that the fact that he thought the gun wasn't loaded. If the jury believes him when he says that would negate the element of intent. Does he get to have the jury instructed on that point? And the answer is yes. The trial court simply made a mistake when it refused to allow this mistake of fact instruction to the jury. And therefore, we've got to go back and try the case again. Does this mean that Hamilton will be acquitted? Does this mean the jury is going to necessarily buy his claim that the gun wasn't loaded? No, absolutely not. And in fact, the Commonwealth put on some really good evidence that the defendant had possession of the gun this whole time, and he should have known the gun was loaded, that there was no reason for him to think to the contrary. But since that is a defense that he has raised, and if the jury believes him when he says that he didn't think it was loaded, that would negate the element of intent, and that would therefore negate the first-degree murder and lower it to something below that, then he had a right to have the jury be instructed on this particular question. We'll get into one more question on mistake of fact, and then we'll move to the somewhat more confusing doctrine of mistake of law.